Akufo Papa Likee TV na message and obachara isu ano heta doma no subscribe. Se me drop in the latest news content abeje bre na so when be atie ne ye bowra ensema ebopopa atifo. Mohwe Supreme Court ruling na ehon sensem bepoma. Majority of them kase the ruling ya Supreme Court Torkornoo make ye ne die. Oye di please president Nana Akufo Addo Emma a lawyer se phone former chief justice for be breed or manual betum say eniema akoso yi de enya kwa. Seems say the chief justice is being manipulated na enona Sophia Akufo so den sembi abebom na mpesi ebowum yetie nsem bi eba de ka ho no ye de nsem bebre mu
is an NDC member of parliament. And I can state without equivocation, and I would invite ECHO to do say, that on the NDC parliamentary caucus platform, as soon as he declared himself and filed, and the notice of post came, it was put on the platform, and he was asked, is this true? He came with an explanation of why he thought he had to go independent.
Is that Memphis Central?
Yes, Pitaka. And then, I think it was either Ayariga or Roxanne, put the constitutional provision of 97 on the page. The gentleman on his own exited our platform.
He exited your WhatsApp platform?
Yes. Because 97 says the member shall vacate as soon as he does it. And since then, Peter Kwacheaka has not come to parliament to sit with us or anywhere else. Because he recognizes what the Constitution says. The Constitution says, once you do so, you vacate your seat. 97 is clear, it's unambiguous. And that's why we keep saying the Speaker did not declare anything vacant, because nothing rests with the power, within the power of the Speaker to declare anything vacant. That vacancy is occasioned by action. In 97, 1 G and H, the Constitution is clear that you do this,
this is the
consequence. So it's as though it's the same way the Criminal Offences Act to say, if I take Professor Jampo's phone without his permission, it constitutes theft. I don't need anybody to explain. Once his permission was not sought, and once I have acquired it for my own use, it is theft. And look, you may like Justice Atuguba or not, but his scholarly exposition this morning on what is going on in the courts should cause for introspection and reflection by any true lover of this country and our democracy. That look, where we sit as a country, and look, it takes a lot for a judge of his caliber to make these comments publicly. Let's not take it for granted. It is also important that we recognize the comments that have been made by Sophia Akufo. What, so Sophia Akufo is also peeved?
I'm not saying so, but he is peeved for not being CJ.
No. The former
make your point.
CJ,
peeved.
the one who picketed. No, that's Sophia Akufo. Yes. Yeah. Again, she was CJ. She's been speaking.
And she's Akufo Addo's relative.
So at the end of the day, when people are speaking, it is important that those in power pay attention. Let me say once again that the logic or lack thereof in the argument by the majority leaves us with a cause for worry.
Okay.
But I will stand at this juncture to respect the exposition of Lovelace JSC and Amadou Tanko JSC. It gives me hope that there is still some modicum of common sense left at the courts. Again, The point must be made here, and I would give you evidence that the Chief Justice is only interested in pleasing the whims and caprices of President Akufo Addo.
Why say that? Why?
First and foremost, the Chief Justice, we all know she was not the most senior person on the courts to be made Chief Justice. President Akufo Addo jumped people and made her Chief Justice. And so to please him, at the last bar conference, she went there and spoke about President Akufo Addo. This same President Akufo Addo who has destroyed his economy, being a legacy president. What legacy is he leaving?
He said he's the best.
He said he's the best.
So like what?
President Akufo Addo has made it clear that he doesn't want to sign the LGBTQ bill. The Chief Justice has single-handedly ensured that the bill doesn't go before President Akufo Addo.
But in this case, it's going to be heard on Tuesday.
Tuesday. Listen,
and they've given the reasoning that the reason for the delay is because
I have lawyers here. I have lawyers here.
And the speaker's lawyers haven't filed.
Stop
but you know this, don't you?
Stop regurgitating.
You know this.
Stop regurgitating the excuses.
You know this.
The excuses that make no common sense. Look, and today the takeaway word from this panel is common sense. Look.
But that is the decision. In fact, that is the explanation they give.
I am telling you that the Chief Justice is lying.
Why?
When the Chief Justice writes to Multimedia, and I've seen the letter because the Chief Justice copies me in the letter to Multimedia, where they write to me, they wrote to Multimedia saying that you granted interviews to me on certain issues and they are setting the record straight, and they copied me in that letter. And I'm saying that the Chief Justice is lying. When the Chief Justice says that the case before the Supreme Court on the LGBTQ has not been fully heard, and so she cannot pass judgment. The injunction case, which is the reason why Parliament cannot transmit, has been fully heard. The Chief Justice on her own decides that even though injunction case has been heard fully, she wants to hear the substantive case before she will rule on the injunction, effectively placing an injunction on Parliament without saying so. And that is the reason why today the clerk has held back until the Speaker's recent declaration that he should resend it. The clerk is saying that because the Supreme Court has not ruled and the Chief Justice intentionally has not ruled. So it is not true that the LGBTQ case, the injunction has not been heard. All arguments have been made. All the positions have been completed. All that is left is for a declaration by the Supreme Court. She's failing to do that because she doesn't want to put. She is supporting President Akufo Addo to support LGBTQ, and it is a shame that the Chief Justice stands in church at ICGC in Tema to preach.
So no,
and she's not willing to walk her talk. And listen, let me tell you something. Let me tell you something. No. It's not about going somewhere. Look, today we are speaking for this nation and we are telling the truth. The Chief Justice is simply seeking to please President Akufo Addo.
What's your point? Because you're just...
And my point is that the Chief Justice is seeking to please President Akufo Addo. And President Akufo Addo and Lawyer Martin Kpebu makes the point that President Akufo Addo has an axe to grind with some people on the bench. Do you know, as we speak right now, they brought 2 judges that Parliament, but that's not the reason they are forcing for us to come, approved to the Supreme Court from the Court of Appeal. Who are the 3 most senior people on the Court of Appeal today?
Thank you. Senor Jamefe.
One of them.
He's the most senior.
Senor Jamefe. He's the most senior. Justice Senor Jamefe. Yeah. He's the most senior. The second one is Justice Dịsgrዀcé. The third is Justice Subare. These 3. Because President Akufo Addo doesn't like them. And I'm saying it without equivocation. Because he knows that they will not do his bidding like the CJ is doing. He has decided to overlook them and has promoted several of their juniors. President Akufo Addo has bastardized the institutions of state. He's over-politicized the Supreme Court. And we must call the president out and his accomplices in the Supreme Court, the Chief Justice. So, look, I am stating emphatically that, look, Afenyo rant, there's an East African proverb that when a thief tells you to go to court, it's because his brother is the judge. Afenyo comes from Winneba. The Chief Justice comes from Winneba.
How is that related? What's the meaning of that?
There's a Winneba connection going on there.
How?
And that's why the Chief Justice is playing this game.
How do you prove?
And that's why the Chief Justice is playing the game she's playing.
How has that reflected in anything?
Listen, it has reflected in the fact that the Supreme Court has purported to give a majority ruling. That is of no consequence. Look, this is the first time you have a Supreme Court. Someone has come to you saying that give me 4 declarations. In fact, seeking 4 reliefs. The first one is for you to make an interpretation subsequent to your interpretation, they want you to grant reliefs to them. That prevents the Speaker or any officer of Parliament, in this case the Marshal of Parliament, from preventing. Because listen, the Speaker can recall Parliament. Yes, the Speaker can recall Parliament and issue an instruction to the Marshal to prevent those 4 MPs from coming onto the floor of the House. And that is what Afenyo went to court seeking. Okay. Now, the Supreme Court claims to have given a ruling, but the ruling does not give them those reliefs. So there is nothing on the Speaker preventing the Speaker. And that is why, once again, I say, thankfully to God, all hope is not lost. The dissenting judgment by Lovelace JSC and Justice Abdullahi Tanko gives...
Quick one.
The Supreme Court made it clear at page 14 of the judgment that they are doing only interpretation, okay? And so that anybody after this interpretation who wants to have those seats declared should go to the High Court. Let's repeat. So the Supreme Court is saying that this judgment, the majority, okay, is only an interpretation. They are not in the business of declaring vacant seats. Vacant seats is for the High Court.
So
and Article 99.
That pending Dafiamekpo case at the High Court, this ruling doesn't affect it?
That's the right forum. Dafiamekpo is in the right forum to have those seats vacated. If you want to vacate a seat and you go to the Supreme Court, you'll be thrown out. So they are very clear. That's how come they said they are not declaring any seats vacant. They've just declared that what the Speaker did is wrong. Now, if you actually want them to say that this seat, okay, should be declared vacant, go to the High Court. That's the law, right? Now, let's also come to this point briefly. Prof, I appreciate the historical antecedents and everything. By an interpretation, when we talk about the intention, when you hear lawyers say intention of the lawmaker, the intention simply means what the lawmaker has captured in the black letter of the law. So I get it that the core of cross-carpeting or crossing carpet, I didn't know there was cross-carpeting. We were used to crossing carpet. That now they say there's also the version cross-carpeting. Right, I'm a political scientist by training, right? So I appreciate that that's the core one, but it also covers beyond. So if we want to limit it to only the one you're talking about, that in Parliament physically crossing, then let's limit it. Otherwise, you see, the Speaker is the most experienced parliamentarian from 1992. He's saying it, and he's saying that it doesn't make sense. Before you can become a parliamentary candidate of a party, you go and join that party. And so they say break in allegiance. Now, you're saying that, look at Mamle, Morrison, etc. They've only kept them because MPP doesn't have the numbers. Otherwise, you think MPP is happy that, let's say, they go to have their strategy meetings and then Mamle Morrison is sitting there. When they see her as a mole...
Vincent, as a says that's a minimal issue which no,
it's not minimal. That's why under Act 300, the Parliament Act, it's the political parties that have control over their members. Once you break allegiance, they send you out.
Okay.
Once you break allegiance, they send you out. So what the Supreme Court was needlessly engaged in is rewriting the Constitution. No, don't rewrite when the words are very clear. The purposive interpretation approach says that when the words are clear, just give them their meaning. Please. When a law is undesirable, you amend. We all agree now that it's time to review the Constitution. So we'll simply add it. If the wishes of the people is that we should limit it to only actually cross-carpeting from one side of the aisle to the other, sure. But Speaker Babin's ruling is that allegiance is very, 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 very important. And also let's note that in contract, there's what we call laws in restraint of trade.
Yes.
Simply, the aspect I'm interested in here is that, assuming Mr. Okanse is a host of this program, your contract of employment can provide that if you resign today, tomorrow you cannot go and join Samson Ladi and Yenini on Joy FM so that you be two hosts of the program. No. Under the common law, it's allowed that your contract will restrict you that you cannot immediately go. But rather, they can put in there that you sit at home for 6 months. Of course, they'll compensate you for that. But you have to make sure that you don't immediately go away with trade secrets and everything from here. It's law. So when the Constitution says that don't join this different party and seek to remain, there is also reason for it. There are these issues of secrets, etc. So let's not just say that, oh, the only purpose of Article 97 Clause 1, G and H is that when you fiscally cross. No, you become dangerous.
So it's not a trivial issue at all.
Yeah.
Okay, and Mr. Sophia, on this matter, because when I asked that question earlier, I said this is one that you would treat as a trivial issue because you'd rather leave that to be determined by the leadership of the party, to the extent that if you have these persons who not just express an intention, because we have the notice of poll that has captured not just an intention, but a reality that they are going to contest as independent candidates in their respective constituencies. No, let's put the notice of polls on the screen. Yes. No, I'm going to a point. Against the elected and sponsored candidate of your party.
To join the next parliament.
No, yes. I mean, that's stated.
So add it.
You say that to the extent that they...
Yeah, I must say somebody breast or daily update TV. So